the tribe doesn't have a whole lot of money, and so and this is provided for under a contract with the government based on a law that was established back in the 60s, the Indian Self-Determination Act. In order to shift from the federal government responsibilities that the federal government were taking care of back to the people, the tribes, and so that they can do school, hospitals, healthcare, roads. I mean, anything that the federal government does within a specific Indian country area is something that, pursuant to a contract with the government, can be turned over to be managed by the tribe. And so. And
okay, and thank you. I understand your position there. Let me have you move to this sixth factor then. Policies underlying the tribal sovereign immunity and its connection to tribal economic development, whether those policies are served by granting immunity to economic entities.
Which, again, the sixth factor is something that is kind of an amalgamation of a couple of the other factors. As far as the relationship between the entity and the tribe, again, it's 100%, right? All the money, all the profits, everything that's left over at the end of the day goes to promote the health and welfare of the tribe by their contract. So, I think the sixth factor is met by all of the other ones, which is it's not distinct enough in and of itself.
All right, Mr. Beckett, this was helpful. Thank you. What I'd like to do now is I'd like to turn to hear from plaintiffs, petitioners, and Mr. McDonald. As I mentioned to you, Mr. Beckett, because the respondents bear the burden here, I will give you the last word here. But I think what I'd like to hear now is from the petitioners, and thank you. I found your arguments helpful. Thank you. And Mr. McDonald, let me turn to you. So the argument that's been presented to me by respondents in the briefing and today is that, number one, this court just simply does not have subject matter or personal jurisdiction over this case. And there's, I think, a concession that while the tribe is not named, that first of all, that the reason for that would be the tribal sovereignty, and that while the tribe is not named as the specific respondent here, what's been argued to me is that, in fact, the respondent entities are an arm of the tribe. And you heard me ask Mr. Beckett here that the crucial question that I look at, first of all, is what's the important test that the court must apply in determining whether, in fact, the respondent entities are an arm of the tribe. And I've gone through the six factors with him. The six factors here. And my question to you is, I'd like to hear your response. Is the framework to start with the six-factor test, or do you see that the court needs to start at a different starting point in terms of looking at the jurisdiction issue? Could you address that question for me, first of all? I want to go through your answers to the six factors, but I guess what I'm first of all interested in is does the court need to reach the six factors first, or is there another step along the way? Could you address that for me?
Yes, Your Honor. Our position would be that the same decisional authority, the 10th Circuit in this case, and even the same in Summerlot and which establishes the six-factor test, is the same authority that posits that six-factor test does not apply to incorporated entities under state law. So that would be a threshold issue.
A threshold issue
yes.
is, first of all, are the entities incorporated under state law?
Yes.
That's the question before I ever get to the six-factor test. Did I understand that?
That's correct. And if I may, I'd like to quote a portion of the Summerlot case. Starting page 1149, it says, quote, "Thus the subordinate economic entity test," which I think the court's also calling the arm of the tribe test, is inapplicable to entities which are legally distinct from their members and which voluntarily subject themselves to the authority of another sovereign, which allows them to be sued. So, and then I could also go into some detail as to the concurring opinion from Judge Gorsuch, again in the Summerlot case.
And I did read
Okay.
that in the briefing. I'll highlight that I did read that.
So, and the court, one other thing that I think also merits emphasis is on page, again from the Summerlot case, is also on page 1149. It says, in concluding a subordinate economic entity analysis applied to this case, the district court overlooked a crucial distinction between CND and the entities at issue in previous cases in which the test had been applied. CND is incorporated under state law. By contrast, the entities which a subordinate economic entity test has traditionally been applied, like the casino and authority in BMG, that's the breakthrough management case, have all been organized in some form or another under tribal law. And then it goes on to cite a case from the Ninth Circuit, Allen v. Gold, Johnson v. Harris, a Kansas case, and then a Nevada case. And it also cites a learned treatise by Felix Cohen, Handbook of Federal Indian Law, Section 7.05, Subpart 1, Subpart A. Quote, although the immunity extends to entities that are arms of the tribes, it apparently does not cover tribally chartered corporations that are completely independent of the tribe.
So, let me ask you this, Mr. McDonald. So, in terms of a decision tree here, if I'm going to frame the decision tree under the case law and the decision tree you would have me follow, if I am looking at whether I have jurisdiction here, and the question then becomes if tribal sovereignty is an issue here, you're telling me the first decision that must be looked at, the pertinent question is, are the respondent entities incorporated under state law? That's what I look at. And in this case, you would have me look at the fact that they were, in fact, incorporated under state law. And because the answer to that was yes, that they were incorporated many years ago, it stops there and the court has jurisdiction. And I don't even need to reach the six-factor test. That's what I'm understanding so far. Let me pause there. Did I understand the argument correct?
About 90%. The other 10% I would add is that these LLCs are still registered with the state. They are still paying they are still maintaining their active status as limited liability companies under state law.
And that's what I'd like to talk to you about next, because what's been argued to me is, so I've heard you just say that they're still registered in Utah as LLCs. What's been argued to me is that I need to give importance to the fact that at some point these entities were amended to be tribal entities. Could you tell me, do you know when that occurred, number one? And number two, and if you don't, that's, I think more importantly, what importance should I give that, or why should I not view that as important? Could you address that for me?
Okay. I think we did. I believe we briefed that. We actually submitted as part of our memorandum Exhibit A, I believe. Let me check on that. Yeah, the certificate of organization, articles and statement of conversion, and so on. My recollection is that the dates that these were converted from regular Utah LLCs to tribal LLCs was in 2020, I believe June and July. That said, we would submit, Your Honor, that that's a distinction without a difference, because under state law, they're still registered with the state, and the only difference is that they're treated as foreign LLCs rather than state Utah LLCs. And we did cite the statute. Counsel said that, no, we haven't addressed that. Actually, we did. On page 4 of our brief, we cited Utah Code Annotated 48-3A-102 Subpart 31, which defines a tribal limited liability company. And that's the 51% definition that counsel said. That's fine. And then the next part, Utah Code 48-3A-901 Subpart 4 Subpart A says that the Division of Corporations and Commercial Code may permit a tribal limited liability company to apply for authority to transact business in the state in the same manner as a foreign limited liability company. And then Subpart B of that statute, and I think this is the key part, states that if a tribal limited liability company elects to apply for authority to transact business in this state for the purposes of this chapter, the tribal limited liability company shall be treated in the same manner as a foreign limited liability company formed under the laws of another state. In other words, the idea that the respondents are saying is that I think would require this court to find that foreign limited liability companies doing business in this state are not subject to the laws of this state. That necessarily fails. Because if you're, say, a Nevada LLC, and you come in and say, hey, I'd like to lease property in IRDA, and here's a contract, and then money changes hands, the contract isn't signed, and we can get into that later. But if a dispute arises there, the idea that this court lacks jurisdiction to adjudicate, in this case, a state law pertaining to wrongful liens, pertaining to real property located in Utah, pertaining to entities. The petitioners are exclusively Utah LLCs, and the respondents, I guess, they're tribal limited liability companies under Utah law, so they're going to be treated as foreign LLCs, but they're still subject to this court's jurisdiction.
So your argument is under the Utah Code, even though they were at one point amended to tribal entities, what the Utah Code makes clear is that those entities are treated as foreign liability entities and are still under the jurisdiction of this court. Did I follow that?
That's correct.
Okay.
That's correct.
Thank you. That's helpful. And tell me again the code statute.
That is Utah Code 48-3A-901, subpart 4, subpart B.
Thank you. Okay, and so again, I'm going back to the framework of the decision tree. So you're indicating to me that if I'm looking at whether I have jurisdiction here and I'm looking at as tribal sovereignty applies, you're indicating that before I even get to the six-factor test, I'm looking at the sole question is the sole question of are the entities incorporated under state law, and that even though at one point they were amended, that number one they were initially incorporated under state law, and even though they were amended as tribal entities in 2020, the statute, the code section you've just read, indicates that it just means that they're treated as foreign entities, and therefore I still have, and that they still reside in, they're still registered as LLCs in Utah, and therefore for all those reasons, the court has jurisdiction. Does not even need to get to the point of the six-factor test. Did I follow the argument there from start to finish? Did I connect the dots?
Yes.
Okay. So let's say that the pertinent inquiry. Let me back up in that chain of the decision tree there to the point of, let's say that the pertinent inquiry is not, that the first question is not are the entities incorporated in state Utah, but that is something that's part of the six-factor test. I'm going to have you move to the six-factor test.
Okay.
Let's say that the pertinent inquiry is the court is to go right to the six-factor test and to see if it's been met. Walk me through petitioner's stance as to whether the six-factor test has been met. And if there's something you wanted to argue before that, go ahead. I do want to see it through the lens of the six-factor test.
Okay, I'm happy to go there. I do think that there would be another threshold evaluation before the court, which would be to just look at the straight-up law on, does this court have at least a prima facie showing of subject matter jurisdiction. We addressed that on page 5 of our brief. We cited case law to the effect that the concept of subject matter jurisdiction relates to the relationship between the claim and the forum that allows for the exercise of jurisdiction. Your Honor, this is not counsel made a reference to tribal court, and which is new. That wasn't a part of any brief. And I think that's significant because for the first time now, we now know that the federal courts lack jurisdiction because that's already been adjudicated. And so the question that I had was then who does have jurisdiction? And I guess the argument is going to be that the tribal court has jurisdiction over a property in IRDA because it owns LLCs that didn't even have some sort of interest in the property. And we would submit that the Utah Constitution, Article 8, Section 5, which says, the district court shall have original jurisdiction in all matters except as limited by the Constitution or by the statute. 78A-5-102, subpart 2. Except as otherwise provided by the Utah Constitution or by statute, the district court has original jurisdiction in all matters civil and criminal. And Utah Code 78B-3-205 says, any person or personal representatives of the person, whether or not a citizen or resident of this state, who in person or through an agent does any of the following enumerated acts, is subject to the jurisdiction of the courts this state as to any claim arising out of or related to subpart 4, the ownership, use, or possession of any real estate situated in this state. We would submit that I think that's probably the clearest indication that the court has subject matter jurisdiction, because we're dealing with real property, and that statute says that this court has jurisdiction over real property. We would also ask the court to consider that we would think that the respondents are conflating subject matter jurisdiction with tribal immunity, sovereign immunity, and those are fairly distinguishable, because counsel is correct in saying you can't waive subject matter jurisdiction, but you can waive tribal immunity. And then as far as personal jurisdiction, again, we have to go back to, well, these LLCs are organized under state law. And the idea that I think it really bears renewed emphasis and repetition that it seems very incongruous under the law to register an entity under the laws of the state of Utah, maintain those entities under the laws of the state of Utah, and then assert we are not answerable to the laws of the state of Utah or to the jurisdiction of the courts of Utah. That's just a fundamental disconnect in the law as I see it. And then another, I think, threshold consideration that the court should look at in addition to subject matter jurisdiction, again, before we get to the six-factor test, is in rem jurisdiction. We cited a case, this is the Equitas Enterprises LLC v. Interstate Investment Group LLC, 2011 UT 82. And that says, quote, a judgment in personam imposes a personal liability or obligation on one person in favor of another. A judgment in rem affects the interests of all persons in designated property, like I think what we have here. A judgment quasi in rem affects the interests of particular interests in designated property. So I guess theoretically this could be quasi in rem, but still in rem. The latter is of two types. In one, the plaintiff is seeking to secure a pre-existing claim in the subject property and to extinguish or establish the non-existence of similar interests of particular persons. In the other, the plaintiff seeks to apply what he concedes to be the property of the defendant to the satisfaction of a claim against him. And then we go on to quote, again, Equitas, saying that the basis of in rem jurisdiction, quote, is the presence of the subject property within the territorial jurisdiction of the foreign state. I think that falls squarely within what we're talking about here. This is a property in Urda. It's not on tribal land. It's not in some other county. It's not on federal land. It's in Urda, which is state land. And the reason why that's important is because that's sort of an independent basis for rejecting the sovereign immunity argument, because the case law that we cited, again, this is the Upper Skagit Indian Tribe v. Lundgren. That case held, quote, tribal sovereign immunity does not apply to in rem suits. Now, and
so let me pause you there. So,
okay.
So you're saying case law stands for the proposition that tribal sovereignty does not apply to in rem suits.
That's right.
Now tell me again the support for that.
That is the Upper Skagit Indian Tribe v. Lundgren, 138 S. Court, 1649. Pinpoint citation is 1650. That was a 2018 Supreme Court SCOTUS, the Supreme Court of the United States case. Now, Your Honor, I should also emphasize that the court in Upper Skagit did not rule that sovereign immunity applied to in rem jurisdiction, as I think respondents implied in their reply brief. The court expressly remanded the issue back to the state court to determine whether it applies. Specifically on page 1654, the court held that, quote, "We leave it to the Washington Supreme Court to address these arguments in the first instance." And I looked it up. So far, it looks like the Washington Supreme Court has not made up its mind one way or the other. The holding in Upper Skagit stands for the proposition that in rem jurisdiction, or that in rem suits are essentially outside of sovereign immunity type issues. So that I think that's what places that as a threshold issue, because the only reason why we need to get to the 6-factor tests is to determine if sovereign immunity applies. If it doesn't apply in the first instance because of in rem jurisdiction, subject matter jurisdiction, and incorporated, and because they've incorporated under state law, then we don't need to reach those.
I understand your position.
Okay.
Thank you.
Would the court like me to walk through the 6 factors?
Yes, please.
Okay.
Let's assume that the court were to decide that the threshold. I understand your argument to be that the court does not need to reach the 6-factor test because there are 2 important threshold questions beforehand, and that plaintiff has or petitioner has satisfied those. I understand that's the argument, but let's say the court decides that those threshold questions are not the starting point, but it's a 6-factor test. I'll have you go.
Assuming arguendo. Gotta love the Latin. Okay.
I'll have you walk through. You heard me. I wanted carefully to hear. I wanted to hear the careful the steps that respondent gave me in terms of the 6 factors. Yeah. I'd like to have the same for you.
Well, as a preliminary matter, I'll notice the extreme paucity of evidence submitted to this court, or rather not submitted to this court. Your Honor, in the Summerlot case, there's dicta indicating that the tribe asserting sovereign immunity presented 71 exhibits pertaining to the multi-factor arm of the tribe test. Here we have 2. We both one is an affidavit from the attorney, and then one is an affidavit from Ms. Baer. So functionally, I think the affidavit from counsel is just, I think, authenticating the excerpts of the deposition. I don't think it speaks as to any substantive underlying factual issue. So we're left with 1 piece of evidence submitted to the courts, and I think that's just not enough here. But if we step into the first factor, the method of creation of the economic entities. Now, respondents claimed, and I was really quite astounded at this, they say, quote, they are tribal entities organized under the laws of the band. Your Honor, that's patently not true. They are not organized under the laws of the band. They are organized under the laws of the state of Utah. They cannot claim to be sovereignly immune. They cannot claim we are independent of the state of Utah, but then go to a separate sovereign, Utah, organize these LLCs. They can't bridge that gap. They have to remain independent. They cannot claim that they're organized under the laws of the tribe. They aren't.
So you're saying that number 1, the method and creation of the economic entities is just not satisfied, where the respondent entities were organized as Utah entities and remain registered as LLCs in Utah. Did I understand that?
That's correct. That's correct. And this isn't inadvertent. This is not accidental. This is not just waiting for the LLCs to lapse. These were organized in 2018, and they have been active from that point to now. State records establish that. We presented state records. Again, this would be Exhibits B and C, I believe, which state that both respondent LLCs are presently, quote, authorized to transact business in Utah, that they were, quote, duly registered under the laws of the state of Utah, that they have, quote, paid all fees and penalties owed to this state in Utah, that their, quote, annual recent reports have been filed by the division of the Corporation of Commercial Codes, unless delinquent, quote, and, quote, that articles of dissolution have not been filed. And then state records also show that both respondent LLCs are listed as current, meaning active, limited liability companies. So, Your Honor, by every metric, the respondent LLCs are organized and existing under the laws of the state of Utah. That they are, for statutory purposes, treated as a foreign LLC is a distinction without a difference, because foreign LLCs can sue and be sued in Utah courts as well. So we would submit that factor militates substantially against the respondents, we would also note that they presented no evidence except the affidavit, and they could have presented all sorts of evidence. They could have said, if they were well and truly organized under the laws of the tribe, why didn't they produce documentation to that effect and submit it to the court and to the petitioners for review? It's in a material sense, they fail in their burden when all they do is say, well, here's an affidavit that you have to take my say-so on it, even though my say-so necessarily presumes that there's got to be a written record, but they hid that, or they failed to disclose it, they failed to produce it. And if they failed to produce it, then that militates against their meeting the analysis, because they're effectively hiding information and material evidence from this court.
To understand your argument there, let me have you move to the second factor, and that's the purpose. You heard my questions to Mr. Beckett, and what was emphasized to me was that when the factor that says purpose doesn't mean that the purpose has to be 100% for the tribe. I'll note that in the briefing, I saw the argument that has been made here by petitioners that the respondent entities are what the respondent entities are helping others, non-tribe members, and that cuts against factor number 2. But what's been argued to me is that doesn't cut against where the purpose does not have to be 100% for the tribe, as long as it's the primary purpose or some purpose. What would you have me look at? How is case law fleshed out purpose, or what would you have me look at?
Your Honor, the case law is basically lays this out as a factor, and I think at that point it becomes sort of fact specific to the individual case. I will note that the counsel did represent to the court that the money generated from the LLCs cannot go back to the court or directly to the tribe.
Correct.
I think that militates somewhat against the purpose because if the services are not intended